Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 ways to avoid spoliation sanctions in litigation. A spoliation sanction is when you get penalized for failing to preserve relevant evidence in a lawsuit. And that can result in the dreaded adverse inference instruction to the jury, which you really don't want. So here are my top 5 ways that you can avoid that happening. Number 5 is the most obvious, and that is to send the client the litigation hold notice very early in the case. One thing you can do to make that easy is put the litigation hold notice in your engagement agreement with the client. And then you know that you have given that notice every time you start a new engagement for a new litigation matter. Number 4 is related to number 5. You know, there is a danger that when you put the litigation hold notice in the engagement agreement, the client may just kind of skip that over and not pay much attention to it. So early on, I would say within the first week, you want to send, it could just be a simple email, it doesn't need to be fancy, but send some reminder telling the client, remember, you need to preserve all relevant emails and other documents so that we don't have to worry about spoliation sanctions. Number 3 is kind of related to number 4, and that is when you remind the client to preserve documents relevant to the case, I would specifically point out that that must include any relevant text messages and voicemail messages. I think with emails it tends to be a little more obvious that those need to be preserved, but these days you find a lot of times there are relevant text messages as well, and there can also be relevant voicemail messages, and you need to make sure those are preserved. Those are easy to forget about and delete. The number 2 suggestion for avoiding spoliation sanctions is that if there is a motion filed seeking spoliation sanctions against your client, you want to make sure that you offer evidence to show that any loss of potentially relevant documents was not in bad faith. So you need to talk in detail with your client about what happened and why, and you want to show that the client at least acted in good faith to try to preserve any relevant documents. The direction of spoliation law generally in the last decade or so has been in the direction of requiring a showing of bad faith before the judge is going to order something severe like the adverse inference instruction to the jury. And finally, the number 1 way to avoid spoliation sanctions is to consider early on in the case getting forensic images made of the computers and smartphones and other devices that are most likely to contain relevant evidence. Now, you don't necessarily have to do that in every case, but you should at least consider it. And in many cases, making a forensic image, and you do that by usually hiring an expert to do it. And it's a relatively standardized process now. It's relatively inexpensive. Having a forensic copy made, let's say, of somebody's hard drive on their laptop, that's probably going to be less expensive than a few hours of attorney time that you would spend dealing with a motion for spoliation sanctions. When you get that forensic image, it's kind of an insurance policy. You can hold that in your file. It's more likely you'll have preserved relevant evidence. It's also evidence of a good faith effort to preserve evidence, and that's important as well. So those are my top 5 tips for how to avoid spoliation sanctions all the way from here in Giddings, Texas, where I've stopped to make this Top 5 Tuesday video. Do you have other suggestions for avoiding spoliation sanctions? Let me know. And hey, thanks for watching.